Hello and welcome to Absolute Trust Talk. I'm Kirsten Howe. I'm the managing attorney at Absolute Trust Counsel. I'm glad you're here today. Today I'm going to do another short episode in this sort of little mini series I've been doing about estate planning misses. I'm talking about misunderstandings, mishaps, misconceptions, mistakes. Things that we've seen our clients have to struggle with over the years, and just want to share some of what we've come to understand in order to help you perhaps avoid these kinds of mistakes. So today we're going to talk about a couple of very specific types of accounts that we see a lot on our clients' homework. They're common. I'm not going to tell you anything you're probably unfamiliar with completely. And they're different from each other, but they do have one very important thing in common, and that is that even though, as I said, our clients might put these accounts on their homework and sort of think of them as their accounts, they legally are not the owners of these accounts. And what I'm talking about are, first of all, custodial accounts, and secondly, 529 accounts. And I'll briefly describe each of them so everybody who's listening, even if this is foreign to you, you'll at least be able to follow the episode. So a custodial account is when an adult has money that belongs to a child. It legally is the child's, but a child is too young to open an account to hold that money. And so the adult opens an account. It's called a custodial account. The adult is the custodian of the account, and the child is, basically the beneficial owner of the account. And once the child turns 18 or possibly 25, in California, we can have custodial accounts that last until 25. Once the child reaches that age, they are able to go and get the money. But in the meantime, the adult, who is called a custodian, is responsible for that account. The other type of account is a 529 account. This is an education account, and it's set up under federal law. Money that goes into a 529 account is considered to be a gift that is made by the person who transfers money into the account. And when they set up the account, they designate a beneficiary, and typically, again, a child, because the purpose of the money is to set aside money, save money, grow money, tax-free, to pay for college is the typical use of a 529 account. But in the case of a 529 account, as I said, it's a gift. The person transferring money into the account is giving up that money. It's not theirs anymore, even though our clients do tend to think of the 529 accounts as their assets, because it's there and it's going to help them pay for college when that time comes. But as a legal matter, the money doesn't belong to them. They've given it away. So where we get into trouble is when either the custodian of the custodial account or the designated owner, the person who set up the 529 account, dies, and something has to happen. And what we would like is for everything to be planned out ahead of time so that the thing that happens is exactly what you want it to happen, and it's very easy. Okay, so we all know, I think, if you've been listening to this podcast even for a couple of weeks, probate is to be avoided. Probate being the court process that we have to go through when a dead person owns property. That's what most people think of when we use the word probate, but probate is also the name of the court that we have to go to. Attorneys like me who practice in the trust and estates area, that's the court we go to when our clients have problems that we need a judge's help to fix. And the things that I just described for you, a 529 owner has died or a custodian of a custodial account has died. I've had these accounts in my practice where we ended up, even though we didn't have to do a probate, we still had to go to probate court to get a judge to help us fix the problem. The problem being that there was no, now that the custodial account owner has died, there's no custodian of the account. So how are we going to manage that account if there's no custodian? And with the 529 account, same thing. There's now no owner. So how are we going to get that money out to pay for college when there's no owner to send the money to the college? Okay, so we got to go to court. We have to file a petition. It takes time. It takes money. You know, that's the worst part. You got to spend a few $1,000s to get a few $1,000s out of these accounts. Sometimes the 529 accounts are worth quite a bit, so it doesn't feel so bad to spend a few $1,000s to get that money. But still, it's never fun when you have to tell a client, okay, we have to spend a bunch of money to deal with this problem. So what do we do? How do we avoid this problem? When these accounts are set up, you can designate a successor. You can, in a 529 account, you are the owner because you set it up, but you can designate a successor owner. They have a form for that. The financial institution where you set it up, whether it's Fidelity or whoever, they have a form. You can tell them, if something ever happens to me, this is the person who will take over this account and be the successor owner. Same with the 529 account, or I'm sorry, the custodial account. If you are the custodian, when you set that account up, you can designate an alternate custodian just in case something happens to you. Now, I'm gonna say also, if you already have these accounts, it's a really good idea to double check and make sure you did those things. If you set up the account so long ago and you just don't remember, just check in, call the financial institution or walk in there and ask, can you please check if I've designated a successor? And you can designate it now. So much simpler, so much easier than having to have somebody like me go to court for you to fix that problem after you die. I'm going to say, similar to these two types of accounts, the 529 and the custodial is what we call a donor advised fund. And a lot of our clients have those. They present similar issues because, again, it's money that the donor has given away, but still has some interest in and still has some sort of control over. And if the donor dies, we need to figure out what needs to happen. Okay, so I'm working on one of those right now, and you know that once I solve it, I will tell you about it in a future episode. I don't have the answers right now about this donor advised fund, but I'm just giving you a heads up. If you have a donor advised fund, talk to your financial advisor and make sure you've dotted all the I's and crossed all the T's there. All right, I hope this has been helpful, and I very much appreciate you watching and listening, and I look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.